equipment is vulnerable to hacking. Its CFO is currently, of course, awaiting extradition from Canada.
Hello and welcome to Bloomberg Quint. You're watching the fine print. The company law is set to be amended yet again. Since its notification in April 2014, the Companies Act has seen significant amendments each year. Just last month, the law was amended via an ordinance based on the Company Law Committee report. And now, the government has proposed further changes to the Act. This time, the changes are aimed at shell companies, corporate social responsibility provisions, and independent directors. Here are the top 3 proposed amendments and their implications. The first key proposed amendment is intended for shell companies. The law allows the registrar of companies to dissolve a company. The ROC can do so if the company has failed to commence business within 1 year of its incorporation or has failed to carry on business or operations for preceding 2 financial years. But what happens to the assets of the company once it's dissolved? The law doesn't spell that out today, and the government wants to change this, and that too retrospectively starting December 26, 2016. The proposed amendments say that once a company is dissolved, its property will stand transferred to the government. A board of administrators will be appointed to dispose of the property, and the proceeds will go to the Consolidated Fund of India. Any relief for restoration in the Register of Companies will need to be sought from the National Company Law Tribunal. The relief, if granted, will be limited to refunds and not transfer of property that's been sold off.
Government is trying to cover a situation where there are several shell companies which are in India. As you know, there are a large number of companies registered. If you see the statistics of companies registered under the Companies Act, there are a large number of companies which are not doing any business activity, but they are just existing as shell companies. There is a genuine apprehension that many of these companies were misused at the time of demonetization, and a lot of money was deposited in the bank accounts of these companies, which apparently were not carrying out any business activity. So the government now is trying to seek an extraordinary power, a power of expropriation, that if the company is struck off the register on the ground that it is not carrying on any business activity, then the government of India will confiscate whatever property is there in the company, except the property which is held in trust for someone else. Everything else will be confiscated and it will vest in the central government completely free of anything charge. And eventually, if somebody makes a claim to NCLT that my property was wrongly confiscated, he has a right to go to approach NCLT and convince NCLT about the veracity of his claim, and then the provision is made that in which case the property can be restored back. But it's an extraordinary power which was never there in the Companies Act. And effectively, generally, this kind of powers are in the fiscal statutes. They are never found in the company law provisions. So for the first time, I am seeing this kind of provision in the company law statute. The section 248 to 250, they came into force on that particular day in December 2016. So the law is made retrospective from the date on which those sections were notified. And the effect is obviously that whatever money was deposited or whatever amount is there, the government acquires an ability to confiscate or expropriate that amount and vest it in the government, and the money will get transferred to the Consolidated Fund of India. So effectively, the government would, as I told you, would like to cover monies which are deposited during the demonetization period, and that would be covered by that.
The second proposed change relates to independent directors. Excessive pecuniary relationship could lead to potential erosion of independence. The Company Law Committee, chaired by Injeti Srinivas, had pointed this out in its report in August this year. Based on this recommendation, the government has now proposed that the sum total of pecuniary relationship of an independent director with the company, its holding, associate or subsidiary company in a year should not exceed more than 25% of her income. There's a further sublimit proposed to this 25% cap. Income from professional services cannot be more than 10% of the independent director's income. Sitting fees of independent directors has been proposed to be excluded from the 25% cap.
What it is trying to do is to take into the sweep of the Act all possible relationships that an independent director may have with the company, and those include firstly professional and service relationships, and secondly any other kind of relationships. Let's say, for example, it could be a trading relationship, just as an example. So what the amendment is doing is imposing an overall limit of 25% of the independent director's income not coming from that company or group of companies or promoters, and within that there's a sublimit of 10% for professional services or other services which may be provided by the independent director to that company or its group. So effectively there is now very clear specific guidelines in terms of what percentage of your income can be received, whether in the form of professional services or otherwise, from a company or its group, for you to be allowed to be treated as an independent director.
Monitoring is going to be a huge challenge for companies because in many cases the people are professional directors. They may not be able to estimate what would be the precise amount of income they'll be earning during the current year. So it will be based on previous year's income, and based on previous year's income they will have to disclose the income tax return to the nomination and remuneration committee of the board, that this is my total income and now you decide how much you can pay me. And if there's a very different amount which a company pays to two directors, it would create unpleasantness at the board level, because everything is disclosed in the annual report. So the directors will come to know what is the income of the director, because based on which you get you cannot exceed 25%. So some directors will get more and some directors will get less.
The final important change that's been proposed is to the corporate social responsibility or CSR spends. Companies which fall within the prescribed thresholds today need to spend at least 2% of their average net profit for the last 3 financial years on CSR activities. If they fail to do so, the reasons need to be specified in the annual report. The government has now proposed an amendment that will make CSR spends mandatory. It is proposed that the unspent amount will have to be transferred in a special account, which will need to be opened by the company for this purpose. This needs to be done within 30 days from the end of a financial year. This amount will then have to be spent on CSR activities within 3 years from the date of the transfer.
This is effectively a mandatory CSR spend regime, and honestly, to some extent for good reason, because some of the reasons that were being given by companies for not making the CSR spend, let's take one example, I won't name the company, but the reason was that before we actually go about making full spends, we like undertaking test projects or pilot projects, and that's the reason which it successively gave for a couple of years. So the intention of the provision was not being met, especially in situations where people were explaining rather than complying. So the regime clearly has now changed to more or less a mandatory regime, with the difference, of course, that you now have a little more time to make that spend. It doesn't have to be in the same year.
And then there is the ILNFS kind of situation fix, one that will allow the government to make an application to the National Company Law Tribunal to declare a director not fit and proper to sit on any board. This, the proposed amendment says, could be used in cases where a person in charge of the management of the company is believed to be guilty of fraud, negligence, or has taken actions to defraud creditors or carried out business in a manner that's prejudicial to public interest. That's all on this week's show. Thanks so much for watching. We'll see you next week.